Welcome to a LAWPRO CPD, brought to you by Title Plus and the Toronto Lawyers Association.
My name is Sophia. I am Communications Counsel at LawPro. I am speaking to you from Toronto, which is also where the offices of LawPro and the Toronto Lawyers Association are located. I'd like to acknowledge that Toronto is on the traditional territory of many nations, including Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. Their stories, their dreams, their spirits linger in the very soul beneath our feet. We honor their enduring connection to this land, a connection that has shaped this incredibly vibrant city. For those joining us remotely, we acknowledge that you may be on the traditional territories of other Indigenous peoples. We extend our respect and gratitude to all of those nations who lived and live in these lands for sharing them with us in peace. Today's program is sponsored by Title Plus. Title Plus Insurance is the only wholly Canadian-owned title insurance product available in Canada. We have three amazing speakers joining us today who are going to share their knowledge and expertise with us. We're joined by Rebecca Hawkridge, Director of Titles for the Province of Ontario, Brendan Fagan, Chief Underwriter, Director of Underwriting at Title Plus, and Raymond Leclerc, Vice President of Public Affairs at LawPro. The program is divided into three parts. We're going to be talking about due diligence requirements stemming from recent legislative changes affecting NOSIs, Notice of Security Interest, claims related to easements, covenants, agreements on title, and fraud, including practical risk management strategies, and last but not least, electronic registration issues, specifically common errors and to avoid return of documents. We have materials we put together. If you're joining us live, they're in the chat. Otherwise, you can go to practicepro.ca, click on CPDs, and then on today's event, and the materials will be there. So without further delay, I will turn it over to Ray to talk to us about NOSIs.
Good morning, and thank you for the invitation to speak. Let me bring up my slides. And perfect. So I've been asked to speak about NOSIs and the impact of that they have created to our practice. It has been 6 months now since the legislation has been passed. It is a period of adjustment for everybody, and we're trying to ensure that lawyers are adjusting as they require. So just a history, the Homeowner Protection Act was passed on June 6, 2024, basically deeming all existing NOSIs to be expired, all NOSIs on title, and banning the registration of any further NOSIs, but specifically only NOSIs that are dealing with consumer goods. There is a definition of consumer goods in the PPSA that are goods that are used or acquired for use primarily for personal, family, or household purposes. There is an issue, and I'll come back to that, is the timing of when that definition is applied. The most important part, and what seems to be getting most people, is that they forget that the ban of the NOSI is banning the notice that is registered on title, but it has no effect whatsoever on the underlying contract. The contractual obligations, the financial obligations remain in effect, and there is no change to those. So even though there is nothing interfering with title for a sale or purchase or a refinancing, there is still the issue of the financial security that needs to be addressed. And we'll talk a bit more about that. So NOSIs no longer affect the real property, which is fine. I'm repeating again because this seems to be the underlying problem. We're speaking to the Canadian Lenders Association. They are indicating that most lawyers are getting it, but a few of them are under the misapprehension that the NOSIs has deleted even the contract. That is not the case. The contractual and financial obligations remain and must be addressed, which means that a seller is paying off the liability or a purchaser is assuming the liability. Now, in the perfect world, when the agreement of purchase and sale is put together, that should be addressed. That is typically, for lawyers, we get the done deal. There is no negotiating the agreement. That's been done by the agents. The issue is, what are the agents, what due diligence are the agents doing? What we see now is, I'm told, basically, they typically put in hot water tank if rented, which is not very useful. But what about the furnace? What about the HVAC system? What about the hot tub? What about the solar system, et cetera, that could be subject of a financial security? So the seller's lawyer also should be wary. All of our clients will sign a bill of sale. The bill of sale says they're delivering everything free and clear. Well, is that correct? What about the furnace? What about the hot water tank? If that is the case, and if the agreement of purchase and sale doesn't exclude them, then the lawyer is in the unfortunate position of having to advise their client that they're going to not get all of the money they think they were getting because they're paying off some liabilities that they had but didn't expect to be paying on that date. So how do you detect the security interest? Well, of course, the agreement to purchase and sale, if it does have it, would be the best place. And I can tell you that I've been speaking with RICO and AREA, who govern real estate agents and brokers. They are looking at setting out some kind of a statement. But basically, we're encouraging them to increase the due diligence. AREA has already accepted some of the changes in that there is a checklist that they provide to their agents that used to say, is there a contract on the property? Well, as you know, clients don't usually know if they have a mortgage, let alone if they have other contracts. And so they've changed the wording to, are you making any regular payments? And hopefully that'll bring up the issue a little bit more. But if not, then of course the agreement of purchase and sale should provide if somebody's paying out the liability or if somebody's assuming the liability. If it's there, then the lawyer does, as we normally would do on closing, is we make the necessary payment or we get the assumption documents and get it signed. If you're doing a title search, of course, if you have a registered NOSI on title, even though it may be expired, I think it's going to be difficult for us to say that we didn't have notice. If they deleted the NOSI and you do your search, because of course you get deleted documents, again, it may be very limited, may be very difficult to be able to say that you haven't got notice. And of course, notice to the lawyer is notice to the borrower, notice to the purchaser, notice to the lender that they're acting for. This, of course, is limited results because, of course, we now know that NOSIs can no longer be registered and they're being deleted. So not quite sure where there is. So where are we? We're basically in the PPSA realm, somewhere where we haven't been in the last while. The government has changed the playing field. They've removed, if you go back at the history, and I have an article that is in part of the materials that goes back into this, but as far back early days before PPSA and before the other legislation, there was legislation in place, and there was a provision that they didn't have to, that they could register on title for the very reason that they didn't want to have lawyers having to do a second search. When the government banned the NOSI, they did not amend that. And so now we're in a situation where we no longer have notice on title, presumably, if there's no NOSI, and the notice is in PPSA. PPSA is not a general notice to everybody, but you have to do search because PPSA takes priority over every other act. And so I think at this point, we are going to be in a situation. Lenders, I'm being told, are spending millions of dollars right now registering under the PPSA for the security interest that they thought they had under NOSIs and going forward, of course, in the situation. Now, the Sales of Good Act, and some have raised, Section 24 says that if you clear title for the purchaser and their lenders, if they had no notice. I'll come back to what is notice. But the Personal Property Security Act, Section 73, clearly gives security of an interest priority over every other legislation. So even though we have a Sales of Good Act, PPSA does override. So the question remains, what is a notice of security interest? That, unfortunately, I think will have to be determined by court, and we're trying to avoid that if we can. So again, NOSI registered on title, probably good notice. A deleted notice, again, probably notice. Notation agreement to purchase and sale, of course, that'll be notice. But what about a sticker on the item? So the hot water tank, the furnace, the hot tub, or whatever other instrument that is secured by an instrument has a sticker on it that says the property of. Now, of course, lawyers don't go to the property. Purchasers and vendors do, but they don't necessarily look at the detail at that point. And that, I think, where it falls on the real estate agent to be looking at these things. It'll be interesting to see where we go. Of course, the Director of Title has provided us with a bulletin, in fact, two bulletins. There was the original 2407 that has been upgraded now to 2412 because they've hard-coded the statement. So good to see the change, and the registry office very much on top there. It requires, though, a lawyer to sign a law statement that the registration relates to a consumer good. Again, what is a consumer good and when do you decide? The PPSA in Ontario does not define when. Every other province does in their legislation. Ontario does not have. The general rule established by courts appears to be that the character of the asset is determined when it's delivered or installed. And so think of a builder. They're building a home that's going to be sold to a new homeowner. The builder installs a hot water tank, which is a rental tank. When do you decide? Of course, when the homeowner is in, it is for their personal and family use. But if you follow the general rule, when the builder puts it in, that's inventory or building material. That's not consumer goods. And so if they register PPSA, it's a legitimate PPSA because it's not for consumer goods. So that is the question that lawyers are going to be looking at, and that's why it's going to be difficult for purchasers to deal with this because they may not have the history to be able to determine. What about a rental property, Airbnb? They install a new furnace. Is that a consumer good? It's for family and household purposes, but it doesn't say the owner's family. And so it may very well be that the courts interpret that as not being consumer good. Again, we have to be mindful of what's going on. I have my article, as I indicated there. One of the things that we did as I worked with the Canadian Lenders Association, and we put together and with ESC, who registers the PPSA, and basically put together a searching guide for lawyers. So if you haven't done PPSA in a while, then you have that searching guide that is there. Important also, there's a registration guide for lenders and their registration agents. So if you're a lawyer acting for a lender, putting a guide on. One of the important things that we did is the problem is PPSA registration requires that you register by the full legal name, which is birth certificate name. Most people don't have their birth certificate name on registered title. And so as a lawyer, you're limited to only the information you have on title, which is the name that's registered, which may not be the birth certificate name. And you have a date of birth. Hopefully it is a correct one, although we know a number of instances where it's not. And so the question becomes, what do we search? And so in the lender guide, we asked, and lenders are accepting that they register as they should under the PPSA for the proper name, but also register under the name that's registered on title. That'll also save the problem if a spouse bought the appliances. They're on the financing statement, but of course she or he is not on title. And so at that point, if they register against the name that's on title, then we'll have a good search. We've had discussions with the Canadian Lenders Association. The lenders are very much monitoring this. They're spending millions of dollars to register PPSAs. They're expecting people to still deal with the underlying contract. We're discussions with RICO and AREA. They changed the checklist, as I've indicated. We're hoping that they're going to accept their new due diligence and make sure that the contracts are complete. We are suggesting that PPSA searches now have become the norm for real estate transactions because of the change the government has made. Even if it's not negligence, it's going to be a reputational use for risk for lawyers and real estate agents. The client is going to come back and be upset that either the seller has to pay or the purchaser has to assume, or the purchaser has to deal with getting with the lender that is now saying pay up or we're going to take the furnace. You don't want those situations. And so I'm suggesting that the lawyers cooperate. Let's cut our work down. The lawyer who does the PPSA search should be the vendor's lawyer. Why not provide a copy to the purchaser? In return, the purchaser does the title search. Why not send a copy of the abstract, the PIN, to the seller's lawyer so they see if there's a PPSA, if there's a NOSI on title, or if there's a mortgage or anything else. It'll be interesting to see what lenders do. We told that lenders may be adding to their mortgage instructions now an obligation to do a PPSA search. Lenders right now seem to be taking in stride and maybe writing off some NOSIs that are not being dealt with, but they're looking at starting to enforce. They're registering a lot of PPSAs, so they're obviously not going to let this go. What will title insurers do? It's clear now that with the NOSI off title, it is no longer a title issue. Is this an off search, a off title search coverage? Again, it has not been the norm up to now. Has the norm changed? When is it accepted to be? Title insurers haven't decided yet, and we'll see what we have going forward. We know that the Canadian Lenders Association is asking all the title insurers to actually add in their application for title insurance policy whether they've done a PPSA search. How LAWPRO is going to respond, we haven't had any claims yet, too early to talk about. Obviously, any claim that we get is we deal with on a fact-specific basis. And so, as I said, this is all a time of transition. This is where people have to adapt to the new reality. And I think the new reality for lawyers is title will no longer give us a complete picture. And whether we're required or it is the best service to clients, is doing a PPSA search to determine if there's any outstanding items that the agents had missed on the agreement of purchase and sale. And with that, I thank you very much for your time.
Thank you, Ray. So now we will turn it over to Brendan, who's going to talk about easements, covenants, notices on title, and fraud.
Thanks, Sophia, and good morning, everyone. I've divided my presentation, as Sophia said, into two very distinct topics. The first will focus on title matters, and specifically easements, agreements, and restrictive covenants, and how title insurance respond to these issues. And in the second part, I'm going to shift gears to talk about fraud, and specifically, I will be covering cyber fraud and exploring the coverage available under LAWPRO's policy and the risks that lawyers face in this rapidly evolving area. So let's begin with the title matters. To provide some context, I'll start with a brief overview of what a title insurance policy does and does not cover. Generally speaking, instruments registered on title, such as easements and agreements, are not covered by the policy simply because they exist on title. In other words, there's no coverage for losses arising solely from the fact that a particular instrument is on title. However, title insurance policies do cover losses related to non-compliance with the conditions or covenants or other obligations contained within those instruments. And additionally, the policies may cover losses from matters that are tangential to these instruments. To illustrate this, I'll dive into specific claim scenarios that Title Plus has encountered throughout the years. These real-world examples will help clarify how the policy responds in practical terms. Occasionally, with respect to easement claims, we see them relating to access problems. In one claim, the Title Plus insured was selling their home, and their title had it together with right-of-way over a neighbor's property for pedestrian access to a parking lot from the rear yard. The purchaser's lawyer discovered that the neighbor did not have the associated subject to right-of-way on their title. The subject to right-of-way on the neighbor's property was originally included in the transfer from the builder, but for reasons unknown, it was never added to the property's legal description. To address this, the lawyer representing the insured in the sale contacted the land registry office to inquire about correcting the omission. The LRO responded that the right-of-way had been ignored in 3 consecutive conveyances, and over 10 years had passed since its omission, meaning that an application would now be required. In order to ensure that the sale proceeded smoothly and on time, Title Plus issued a new policy for the purchaser, insuring over the issue. The claims department retained counsel to resolve the matter by filing an application to correct the legal description of the servient land. This process required obtaining the consent of the owners of the neighboring land as well as their mortgagee. While this error should have been uncovered by a standard title search at the time the insured purchased the property many years earlier, the claim highlights that such mistakes do occur. That's especially true in busy legal practices where oversights can happen. The title insurance policy not only covered the cost of resolving the issue, but more importantly, it enabled the transaction to close on time, demonstrating the value of title insurance in addressing these types of challenges and indirectly protecting the lawyer against a negligence claim. A different type of easement issue arises when a party claims an unregistered easement over uninsured properties. We see these claims stem occasionally from neighbor disputes. Unlike the previously discussed scenario, unregistered easement risks involving neighbors or possibly members of the public, those are generally beyond a lawyer's ability to mitigate for their client. When such a claim occurs, the standard residential policy typically provides coverage against the risk of someone asserting an interest in the insured's land. The title insurer would cover the legal and any associated costs of defending the insured's title. If the dispute goes to court and the unregistered easement claim is upheld, the policy may also cover any resulting loss from a diminution in value of the property. One point I'll make is that it's important for lawyers to carefully review each policy that they order, as certain risks could be excluded depending on the transaction. So for example, a title insurance policy for vacant land may not cover the risk of unregistered easements. I'll now discuss the coverage related to municipal agreements on title. While not the most common type of defect, when these issues do arise, they can be complex and overwhelming for homeowners, excuse me, especially when dealing with a municipality. Several years ago, Title Plus handled a claim from an insured whose basement was flooding after heavy rainfall. Water was pooling around the house, and it was eventually determined that the builder had failed to grade the property as required by the municipality. This failure prevented water from properly draining away from the house. Through an engineer retained by Title Plus, the issue was identified and the reason for the defect was confirmed. Since the grading was non-compliant with the registered municipal agreement, all of the engineering and construction costs were covered under the title insurance policy. The final title matter I'll address is restrictive covenants. A restrictive covenant is a legal agreement between two private parties that restricts the use or occupancy of real property. While they are more commonly associated with commercial properties, restrictive covenants can also affect residential properties. And although these restrictive covenant issues don't often result in title insurance claims, it's crucial for lawyers to understand how the title policy coverage works in order to avoid your client suffering a loss and then, as a lawyer, avoid a potential professional liability claim. As mentioned earlier, title policies do not cover restrictive covenants themselves, but rather the non-compliance with the conditions contained therein. A potential issue could arise for a lawyer who fails to review a restrictive covenant on residential land that a client is purchasing. For example, if a covenant limits the land to a single structure and the client intends to build a second one, the lawyer could face a negligence claim for failing to provide the proper legal advice. In this example, the title insurance policy would not cover any loss suffered by the insured owner for the reason that the restrictive covenant would be accepted from coverage. However, if we change the facts of this example to the client having purchased residential land that already had two structures, which would be in violation of the covenant, the title policy would cover any resulting loss related to that violation, as that would be an existing title defect as of the policy date. It's important to note that the search requirements of title insurers will often differ between residential and commercial policies. Lawyers must be aware of these distinctions to ensure proper protection for their clients. So that's what I have for the first part of my presentation. And I'm now going to move on from that onto the second topic of cyber fraud. If you had slightly turned out during what I just covered, I don't blame you and you're forgiven. But perk up for this one because this is interesting and the risk to lawyers is starting to get somewhat extreme. Now, with respect to the insurance policy that I'll be discussing, and just to be clear, what I had just discussed only dealt with the title insurance policy. And now what I'm going to be discussing will be the LAWPRO E&O policy for lawyers. Over the past several years, we've all witnessed the increasing prevalence of cyber fraud, whether through news headlines or professional or education and training sessions. Unfortunately, the risk has become a significant concern for nearly every sector, including the legal profession. Lawyers have become prime targets increasingly for cyber criminals, primarily because they handle large financial transactions and have historically lacked the most up-to-date IT systems, although this is starting to improve. Starting in about 2022, LAWPRO observed a notable uptick in cyber fraud claims, a trend we expect to continue. Compounding the issue is the fact that LAWPRO's policy sublimits for cyber crime-related claims can leave lawyers exposed to potential uninsured losses. In this presentation, I'll begin by briefly revisiting the policy's coverage limits as they pertain to cybercrime and social engineering risks. We'll then explore some of the ways lawyers are vulnerable to these threats and conclude with actionable steps that you and your staff can take to reduce exposure. As a really quick refresher, the LAWPRO policy provides coverage in the amount of $1 million per claim and an aggregate of $2 million per policy period. However, these limits are not applicable when a claim involves cybercrime or social engineering, which are specific exclusions in the policy. Cybercrime is defined in the policy, and I'll paraphrase here, as an intrusion or attack of the insured lawyer's computer system. And this would include all electronic devices such as cell phones as well. Social engineering is defined in the policy as well, which I won't read here, but I'll describe that more generally in terms of lawyers. It's the use of deception or manipulation to coerce a lawyer or their staff into divulging or transferring personal or confidential info. And this typically includes an action that will induce a lawyer or their staff member to transfer funds to the wrong party. Social engineering is essentially the human-related component of cyber fraud, although it can also be used outside of computer systems, such as a fraudster attempting to obtain information via a phone call. The success of this social engineering fraud is it's based on a deep understanding that these fraudsters have about human behavior and their great ability to employ psychological trickery against people. Now, in terms of what the policy covers, cybercrime is a complete exclusion in the LAWPRO policy, but there is some coverage given back by way of endorsement number 14. This endorsement provides coverage up to a sublimit of $250,000 per claim and in the aggregate. The exclusion and endorsement apply when the lawyer suffers a cyber intrusion into their computer system. The social engineering exclusion limits coverage also to $250,000 per claim and in the aggregate, but the coverage can extend this limit to the normal $1 million per claim and $2 million in the aggregate, if the requirements contained in the exclusion are met. I'll discuss that in a couple of minutes. This exclusion only applies, though, if there is no cyber intrusion into the lawyer's system. So it's completely separate from the cybercrime exclusion. To summarize this point, then the cybercrime exclusion applies to a lawyer whose system was hacked, and the social engineering exclusion applies to a lawyer who is the target of a fraudster, but whose computer system was not breached. What this means in practice is that in any loss that involves the lawyer's system being hacked or breached, the cybercrime exclusion applies, and the social engineering exclusion will have no application to a claim submitted to LAWPRO. If the lawyer's system is breached and the fraudsters then employ social engineering against the firm to steal funds, the analysis of the claim still ends with the cybercrime exclusion. To illustrate all this using a straightforward transaction as an example, consider a purchase and sale where the seller's lawyer's computer system is compromised by a fraudster, leading to revised banking instructions being sent to the purchaser's lawyer. The purchaser's lawyer thinks they're sending their client's money to the seller's lawyer, but it's actually going to the fraudster. In this scenario, the seller's lawyer's claim would fall under the cybercrime exclusion, while the purchaser's lawyer's claim would fall under the social engineering exclusion. While the fraud was a cyber fraud, the purchaser's lawyer's computer system was not infiltrated. So under the policy, the purchaser's lawyer was the victim of the social engineering and not a cybercrime, as the policy defines those terms. I mentioned a couple of minutes ago that the social engineering sublimit of $250,000 can be extended to the full policy amounts if the exclusion requirements are adhered to, which I can briefly summarize here. There needs to be written instructions in a retainer or other agreement regarding the transfer of funds. The insured is required to take steps to verify independently that any changes to instructions are legitimate. And the insured is required to explain to the other parties to the agreement that those parties must contact the insured lawyer if they receive a change to instructions. Now, to help simplify compliance, a chart detailing these requirements in plain language was prepared by LAWPRO. It's on the LAWPRO website and included in today's materials. I encourage you and your staff to review it carefully and ensure your office procedures align with these safeguards. The materials also include a wiring funds checklist, example retainer language, and a couple of other documents on the topics of social engineering and wire fraud. I'm now going to talk about how cyber fraud is occurring these days. Cyber criminals use various methods to infiltrate law firm systems, with phishing attacks being the most common. Other vulnerabilities include weak or compromised passwords, unpatched software, and using public Wi-Fi networks that can be easily exploited. From what LAWPRO has seen, almost every cyber fraud claim that has come in involved a phishing attack. And phishing has a goal of coaxing confidential information from a person through deception. It's usually done through an email that appears to be legitimate and that contains a link. Once the link is clicked, it brings the person to a legitimate looking site, which typically asks them to sign into the account or to download something to their computer. Now, at this point, the cybercriminal has access to the system. In most cases, access is gained to the email system, but in more serious and sophisticated attacks, access can be gained to the entire network. Once these criminals employ the sophisticated schemes, they're often leveraging social engineering to deceive their victims. So, for instance, a fraudster might get into the system and then impersonate a lawyer and instruct another lawyer or staff member of the same firm to transfer client funds. In such cases, the fraudster uses the lawyer's actual email account or address, thereby making it appear legitimate. Another tactic involves impersonating a client or opposing counsel, which would, of course, be outside of the firm's system, and they would provide revised payment instructions. In this case, since the person who's being impersonated is outside of the system, right, the fraudster will typically use a slightly altered email address that might go unnoticed. For example, changing an I to an L or a 0 to a capital O. These schemes prey on trust and routine processes, and it makes vigilance quite critical. Now, the risks don't stop there, though. In cases that can be even more nefarious and sophisticated than social engineering, hackers can access a firm's trust account and transfer funds out themselves, or deploy ransomware to lock systems and steal sensitive data. Such attacks can result in financial losses, reputational damage, and legal repercussions, such as lawsuits and complaints to the Privacy Commissioner. I'm going to talk about what lawyers can do with respect to protecting themselves, their firm, their systems, etc. And prevention is the key to these risks. And while significant, the good news is that you can prevent many cyber intrusions with the right systems and practices. Some simple yet effective strategies are implementing two-factor authentication for added security. While no single step is perfect, two-factor authentication is both incredibly simple and effective. Using strong and sophisticated passwords and changing them regularly. Maintaining robust antivirus software and keeping all of that software up to date. And establishing a regular data backup system to ensure that you're not held hostage in a ransomware attack. There are also some necessary steps you can take to avoid social engineering fraud, such as pay close attention to the details of your file and the details in correspondence. If something seems unusual, such as a client suddenly asking you to transfer funds to an unfamiliar account, it's important to question that. For example, if you have a regular client who has been using the same Ontario bank account for 20 years and that you've been sending funds to for those 20 years, and then prior to a transfer of funds on a new file, the client requests by email for you to send the funds to their account at the First State Bank of Montana, don't send the funds there. This leads to the next point, and probably the most crucial one. Always verify revised instructions independently. For example, call the party who purportedly sent the revised instructions using a number provided at the outset of the file. Don't call them using a number in the email that you're questioning, and don't reply by email, because if it is a fraud, you'll be corresponding with the fraudster. Important as well to continue to educate and train yourself and your staff on this risk. There are many online options available that will provide you with up-to-date information about the latest scams and what to be on the lookout for. One more option to consider is to have simulated phishing attacks sent out to test yourself and your employees to see if they can spot phishing attacks, or you'll find out if your team is falling for them. Here at LAWPRO, if an employee fails a simulated phishing attack that the IT department has sent out, the employee is required to attend a 30-minute mandatory cybersecurity training session. I started at LAWPRO in March of this year, and about a month into my role, I saw my boss, who's an executive here at LAWPRO, skulking off to some remedial IT training, like a scolded little boy who didn't do his homework. He got caught. So here at LAWPRO, we take these issues and risks very seriously. For those of you who employ the services of an IT consultant, you may want to ask them about sending out a simulated phishing attack every so often. And depending on your firm's enterprise software, you may be able to initiate that yourself as well for your staff. I'll also make the point that it's important to foster a culture within your firm where employees feel empowered to raise concerns about banking information and payment instructions, even with senior partners and lawyers. Lastly, consider investing in standalone cyber insurance to provide excuse me, additional protection against these potential losses. To make a final point about the importance about protecting your practice, the LAWPRO coverage can, of course, be quite helpful and can assist. And we've covered many full losses that were below the $250,000 cybercrime limit, and social engineering limit. But we've also seen many claims in which the maximum indemnity was paid out, and the lawyer is then being left to deal with a massive uninsured loss. And potentially more devastating to a practice is the theft of data from a lawyer's system. I'll now touch on how to respond to a cybercrime incident. If the worst has happened and you suspect you've been the victim of an attack, it's crucial to act swiftly. So contact the bank immediately if funds have been sent to the wrong account, as there may still be time to freeze or to recover them. We've seen that quite a few times, and that's led to some successful recoveries. Cease all normal business operations and consult an IT expert for some guidance. We've seen, unfortunately, that there have been lawyers who, after discovering that their system has been infiltrated, have reported a claim to LAWPRO, but then had continued conducting business as usual, therefore allowing the cyber criminals to continue to monitor their work and monitor the client confidential info. Notify LAWPRO and any other relevant cyber insurance provider you may have. Lastly, implement an incident response plan to minimize damage and recovery time. There's a document from LAWPRO that provides information about this kind of plan, and it's included in today's materials and is on the LAWPRO website as well. So as lawyers, we must recognize that the world has changed. Cybercrime is not a distant threat, it's a present and a growing risk. Strategies that I've outlined today may seem inconvenient and admittedly might be burdensome at times. But just imagine the consequences of falling victim to this kind of attack. Just using some numbers as a for instance, if $1 million of a client's funds are stolen, you've accidentally sent them out to the wrong account, you might have the LAWPRO coverage up to $250,000. That leaves you to answer for the remaining loss of $750,000. Worse yet is a ransomware attack that could compromise sensitive client files, which would result in severe reputational and financial damage. And while only a small percentage of lawyers may be affected, cybercriminals are becoming increasingly successful in their attacks, and this success means they will continue to target our profession with growing frequency and sophistication. I'm going to end on a few points, which are the points that we'll call the takeaways from this. So point 1, implement two-factor authentication and have strong passwords. Point 2, always verify revised instructions independently. 3, always raise questions about requests that are abnormal and in the context of a legal transaction. Some things, for example, you'll do 100 transactions and you do A. In the identical transaction, opposing counsel is asking you to do B. That doesn't make sense. Pick up the phone, speak to the lawyer about that. Lastly, and as Ray likes to emphasize, and as I will do here well, it takes a team to prevent cyber fraud at your firm. Everyone needs to be following the same rule book, and everyone needs to feel very comfortable raising concerns to lawyers and to senior partners. And it's important to foster that kind of culture. And that's it. Thank you.
Thanks, Brendan. I was telling Brendan when we were speaking earlier this week about one of our campaigns is call before you click, picking up the phone, making that call. I said to him, I got a text message from DHL about a personal delivery. So this is not work order, this is personal. And I know I'm supposed to get a packet from DHL and there might be some duties that are owed. And I was sharing with Brendan that everything looks legitimate. it's from DHL. It looks like the right link, but I'm afraid to click. And then he said, well, why don't you just call them and then you can confirm, whatever they're asking for. And that was a great suggestion, Brendan. And I did call and it was legitimate. But I think we're scared to click on things that might not be legitimate. It looks very realistic. So I'm very vigilant personally, but also professionally. So thank you, Brendan. Next, we are going to hear from Rebecca on electronic registration issues.
Good morning, and thanks for inviting me to speak here today. I will be talking about avoiding returns for correction and withdrawals. So nobody enjoys having a document returned or withdrawn, and we do not enjoy returning or withdrawing documents. So hopefully this topic will be useful for everyone watching. I'm just going to start by with a couple of reminders. So e-notifications. E-notifications are email notifications, and you can select different options of what you would like to be notified of. The sign up is available through TerraView. Right now, we have approximately 80% of people signed up for e-notifications. You can select e-notifications for documents that have been returned for correction. This is extremely useful if you are not logging into TerraView every day, because you will then get an email that will allow you to go in and look at the messaging about that particular document. So if you have not signed up, please do sign up for e-notifications. The second reminder is that you can view the certification status of your documents from your TerraView docket. And this includes reviewing whether a document has been returned. So if you look at the status column in your docket, you can see whether a document is receipted, registered, which indicates it has been certified, or returned. So this status is not live. If a document is certified, it will then flip to registered the following day from receipted. But it is a useful tool to have. So in preparing for this presentation, I had a look at which documents were causing the most returns for correction by percentage. So which are the documents that are causing the most confusion or problems? And I picked those. I'm going to walk through some of the more common reasons for the returns and how you can avoid making these mistakes so your documents are not returned. So the first one I wanted to talk about was Section 71 notices. So Section 71 of the Land Titles Act permits a notice or a caution to be registered in respect of an unregistered estate, right, or interest in land. Now, it does not permit the registration of a notice in respect of every estate, right, or interest in land. It only permits notices in respect of those notices that are permitted by legislation, so specifically, or those that are approved by the Director of Titles. So please, before you submit a notice, ensure that it is a type of interest that may be protected by way of notice. We are also seeing issues with notices attempting to secure unsecured loans in default. So things like promissory notes, loan agreements, commitment letters, debentures, agreements that provide for fixed or floating charges may not be registered as a Section 71 notice. If those agreements provide for a right to call for a charge, then arrangements would need to be made to properly authorize that charge and register the charge. If you have a right to call for a charge and that right has crystallized and the borrower will not authorize the charge, a caution may be an appropriate registration, but a Section 71 notice would not be. The next document type I wanted to talk about was powers of attorney. And I was actually surprised at this document showing up as a higher than average return for correction rate because it seems quite straightforward. But the problem with it is also straightforward and easily avoidable. So the most common reason a power of attorney is returned for correction is that the donor or donee's names do not match exactly as between the power of attorney and what's entered into the instrument. So they have to be an exact spelling. If there's middle names included or initials included, make sure you also include them in the instrument, and that will avoid that return. Only the acting attorney should be listed in the donee field. So if you have multiple attorneys, but only one is acting, then that is the attorney listed as the donee in the instrument. If you have a power of attorney that appoints substitutes or allows for substitutes, and it is a substitute attorney who is acting, make sure that you include a statement to explain the substitution. So restrictive covenants are another document type that are more frequently returned for correction. The requirements for restrictive covenants are actually set out in the Land Titles Act itself. So before you submit a restrictive covenant for registration, I would advise you to run through this sort of checklist. A restrictive covenant is meant to be a self-imposed restriction on the use of land. So only the covenantor, the owner of the land, may impose the restrictions on their own land. So the covenantor has to be the applicant. The covenantor must own the burdened lands. The covenantor and the covenantee must be different people or entities. So there's no such thing at law as a self-to-self restrictive covenant. So you need to make sure that you have two parties and that the covenantee actually owns benefiting lands. So unless there is a statutory exemption, there's no such thing as an equivalent to a restrictive covenant in gross. There are some statutory exemptions. For example, restrictive covenants under the Conservation Lands Act. But generally speaking, there must be benefiting lands and they must be identified in the instrument with some specificity. So you would not put something like all the land I own in LRR 20 or every Walmart in North America as the benefiting lands. You need to have some specific land that's identified as being benefited. The restriction also has to restrict the use or activity on the burdened lands, not on outside lands. And it has to be negative. So basically, it can't compel action on the part of the covenantor. Some examples of a classic restrictive covenant would be a covenant not to build, or a covenant to only use the land for a specific purpose. For example, this land may only be used as a place of worship. Some things that we see that are not acceptable as restrictive covenants are things like warnings or conditions. So, for example, an environmental warning that says this land is in a floodplain, and that's what's supposed to constitute the restrictive covenant. That is simply a warning. If the document would say, there is no building on this property because it is in a floodplain, that would restrict the use or activity on the burdened land. Another thing that would not be acceptable would be conditions. So for example, a condition that says a building permit will not be issued for this property unless the building permit drawings indicate X, Y, and Z. That would be a condition on the issuance of building permits. Another thing that we sometimes see is attempts to restrict people from objecting. So a covenant that I agree or I am restricted from objecting to the zoning or a building permit on your land would not be acceptable as a restrictive covenant for registration. So please bear that in mind before submitting the restrictive covenant for registration. Another document type, or document types actually, because there are 4 different court order document types that we sometimes see issues with, are court order document types. Just generally speaking, only formal issued orders may be registered on title. So an endorsement may be effective immediately, but for the purposes of registration, you need to actually get the order issued and attach it to the court order document type. Only court orders that are related to title can be registered on title. So if you have a court order that awards you costs, you can't then try to secure the costs against title by registering that court order if it doesn't provide that it provides for a charge against the property. The property, as you know, land registration system works on legal descriptions and property identification numbers rather than municipal addresses. So please remember always to identify the property by legal description, PIN, and LRO. It's fine to also include the municipal address, but that is not how we determine whether a certain court order affects a certain parcel. If the order is asking or requiring that instruments be added or removed to a certain title, then those instruments should be referenced by the instrument number rather than add the charge to Bank of Nova Scotia or add the easement over Part 6. And for more information on court orders, which document type to use in different scenarios, what we can and cannot change with respect to the register, and how to actually remove court orders once you have registered them, please have a look at Bulletin 2024-02 because that goes into more in-depth information on these document types. So we continue to see errors in capacities and shares. And these can easily be corrected when your clients are alive. So if your clients are still alive, they can do a self-to-self transfer to correct any errors in the capacity or shares. Unfortunately, if one of your clients or both have passed away, it can sometimes prevent the registration of a survivorship application if the joint tenancy wasn't properly specified and created. So just a reminder that a blank capacity, if a document is registered, a transfer or charge is registered with no capacity, that will result in a tenancy in common. There will be no right of survivorship. Distinct shares should never be ascribed to individuals or entities that hold as joint tenants with each other. So if everybody is a joint tenant with each other, then there are no shares. Joint tenants have an undivided interest in the property. And if that interest is the whole property, then you do not need to specify shares. If the joint tenant's undivided interest must be expressed because they hold as tenants in common with another owner, then the joint tenant share should be expressed as the part of their undivided interest. So let's just have a look at what this would look like. So here are some examples. First example, you have Bob and Alan, and they are joint tenants. There are no shares specified here. Because they are joint tenants with each other, they own an undivided interest in the entire property. This is a correct way of showing the shares and capacity when everyone is a joint tenant with everyone. Second example, Bob and Bibi, we have joint tenants again, but this time shares have been specified. Now, joint tenants cannot have unequal shares. They have a unity of interest. So this is not the proper way to express a joint tenancy. This is going to create a problem because it is unclear whether they are meant to be tenants in common with a 40% interest and a 60% interest, or if they are actually meant to be joint tenants. The third example, Bob and Bibi again, with a joint tenant's interest in undivided 20% interest. So together, they are joint tenants for 20%. They own with Ashok, who is a tenant in common with them and owns 80%. You'll notice here that Bob and Bibi are shown as part. They own a part in the undivided interest, 20%. So we have not divided this 10 and 10, not 5 and 15. They are both identical as to the whole. The last example, everybody here is a joint tenant, but everyone here is not a joint tenant with each other. So this sometimes happens when you have couples owning property, and they want to have survivorship as between the two people in the couple, but not as between the couples. So here we have Bob and Bibi, joint tenants. They have 20% interest or 50% interest, and they own as tenants in common with Ashok and Tallulah, who have the other 50%. In this case, this is the proper way to indicate the joint tenancy and the joint tenant's interests, but you're going to need to add a statement 61 to specify which one of these owners is joint tenant with which. So Bob with Bibi, Ashok with Tallulah. Another thing that sometimes causes problems is the transfer of a partial interest. So if your client is only transferring part of what they own and they are retaining an interest, then statement 12 is supposed to be used. And statement 12 reads, this transaction deals with a percent or fraction interest of property in the property interest in the property. So some people use this statement when their client is a part owner, but is transferring everything they own. This statement to land registry staff indicates do not remove this owner from the ownership field. This indicates to land registry staff that they have retained an interest. So unless your client is retaining an interest, you should not be using the statement 12. Another thing that sometimes causes confusion is what percent or fraction do you enter into this statement? So if you have a client who owns a 50% interest in the property, and let's say they want to transfer half of their interest to their son. So then do they put in the statement 12, this transaction deals with a 50% interest because they're transferring 50% of their interest? Or do they put 25% interest because that is the end result? Their son will own 25%. The correct answer is that they should put in 25%. It is the percent or fraction of the whole that is entered into a statement 12. So this relates to documents generally, not to a specific document type. Sometimes we get documents, agreements that attach a whole raft of documents to them. Photographs, copyrighted reports, sketches that you can't actually read, even if you magnify them to the maximum permissible by the system. When you prepare documents that you intend to register on title, please ensure that they can be PDF'd in a way that will maintain the legibility. So think about whether the sketches will actually be legible. Remember that they will not appear in color. And also that hyperlinks will not work once a document is in the land registry system. And the document itself must contain the entirety of the agreement. So when you register a document in the system, and that is to be the agreement, it can't then link outside into temporary content that may not be available at the link years from now when somebody is trying to view it. The last thing I wanted to touch on was a couple corrections for the most common mistakes. So most common mistake is a typographical error in the name of the transferee or in the name of a chargee. And there's a simple fix for that. That is the application to change name owner or application to change name instruments type, depending on whether it's a transfer or a charge. Another issue that we get sometimes inquiries about on how to go about correcting is an incorrect date of birth in a transfer. We've been asked, how can we correct these? It's by an application to amend, although we cannot actually go into a transfer and alter the fields. So it's an application to amend just for the purposes of sourcing it for later deletion. But this will place on title notice of the correct date of birth. This is actually the statements and how to remove this document, how it will later be deleted, are set out in my written materials. So you will have those as a reference to look at should you ever need to make this correction. And that brings me to the end of my presentation. Hopefully you found things that will be of use to you in there. Thanks very much.
Thank you so much, Rebecca. So just as Rebecca mentioned, there is just slightly over a page long document on correcting birth dates on title. So that's in the materials. We've had a lot of questions about where the materials are. So if you're joining live, it's in the chat, or you can go to practicepro.ca, click on CPD and today's event, and the materials are there. The replay of this program will also be there in about 1 to 2 weeks. So now we will go through some questions. There are a lot of questions, and we won't be able to address all of them, but I invite the presenters back, and I have some specific questions for the presenters, but feel free to jump in if there's somebody else I could answer. Ray, there's in different formats, people have asked, what is the purpose of deeming NOSIs to be deleted and then requiring, or lenders are going to register under the PPSA and now requiring searches under PPSA? I think there's some confusion on what is the purpose as a whole.
So I guess that the biggest accomplishment of the Homeowners Protection Act is that it's freed the title from being hostage to these NOSIs. When you had the bad actors, the sale and the purchase or the refinancing could not be completed until the NOSI was addressed and was discharged. And you could only get a discharge if you paid the exorbitant amounts that basically the bad actors were calling for. Obviously, that was not all NOSI owners that had it. So that's the biggest change. It's basically just it's freed title. Title is no longer subject to it. You now deal with the security interest in a different timeline. It doesn't have to be done for closing. It can be negotiated before, after, during the closing, and if need be, it can be dealt with properly in the court venue as opposed to being held hostage for the closing. And that's the biggest change. It has not changed the underlying contract and financial obligations.
Thank you. Ray, there's a few questions you've answered in the chat, but I'll just pose them live. So for the benefit of everyone who's not reading the chat, have any of the major lenders modified their due diligence requirements to require PPSA searches on residential real estate transactions yet, to your knowledge?
Great question. As of yet, we don't know of any that have. Speaking to the Canadian Lenders Association, which many of the lenders are part of, they are now discussing exactly adding to the requirements of a mortgage to do a PPSA search. What they're going to ask for, we're not quite sure. That hasn't been determined yet. But they are spending lots of time and money to register NOSIs, to register PPSA security interests. So they're going to want to have that. And I'm told that most of the lenders who do mortgages are also very much involved in financial security or in PPSA security also. So they have an interest to be there. And in fact, a mortgagee does not want to be subject to a secured interest because, as I said, the PPSA it governs over every other piece of legislation. So that's probably something that's coming. Hopefully they won't hide it in the 30, 40 page instructions as a one line, but we will, if we do learn of that, we will probably notify the profession.
Thanks, Ray. Ray, I'm going to give you a break. I'm going to turn it over to ask a question to Brendan, and we will come back to you, Ray, in a bit. Brendan, there was a clarification question. In the flooding house example that you had, was there a work order issued by the municipality?
No, there was no work order that was issued. There was no building permit that was open that would have necessitated a work order. It was just a violation of the conditions regarding the grading in the municipal agreement.
Okay, perfect. Thank you. This question is about easements. Should a lawyer's title opinion explain to the purchaser what a right-of-way easement means? For example, Does the easement allow them to cut down trees and widen the lane within the width of the right-of-way without the landowner's consent?
Yeah, so the lawyer should be going through the easements that are registered on title and reviewing them to see how they might impact title, whether, for example, if someone has the right to cross over their land to access neighboring property, or in this example, it would be important for the lawyer to explain that, yes, someone can come on the land and to cut down trees that are adjacent.
Thanks, Brendan. I think one of the things that we see in LawPro when we get claims is documentation is really, really important. So you can explain, you can talk, you can speak verbally, but to document in your file, and I think everyone knows this, but it's a good reminder to document even things that you think are little or maybe insignificant in your file. And ideally, to send it back to the client in writing so they have it. Email is great. We talked about this today. This is the question you asked, and here's the answer. Brendan, we'll come back to you in a little bit. Rebecca, this question is for you. And there are a few versions of this question. So regarding POAs, if there are two attorneys named to act jointly and severally, and only one of them is giving instructions to register, do you mean to only register the POA with the one attorney as a donee, or are both attorneys to be listed as donee?
So it depends if one of the attorneys has recused. So if one of the attorneys is not acting and they may act severally, then only the attorney acting should be registering the power of attorney. Because if they go on title that way, so if you have two attorneys who go on title or then trying to deal with the property, they'll both be required to sign off on those instruments. So you want to make it clear if there's only one acting attorney who can act independently, that is what we have knowledge of.
Okay, perfect. And a follow-up question asked by another attendee. So if the acting attorney is a sole donee, can the registered POA still be used by another appointed attorney on a future transaction utilizing the POA, or is further registration by the different attorney required?
So there's a substitute, and now the substitute is acting?
Say yes.
Okay, so if the substitute is acting, we would need a statement as to the substitution. Right, we would already have the power of attorney registered, but for that person to use it, we would need a statement detailing the reasons for the substitution and confirming that they are now entitled to act pursuant to that power of attorney.
Thank you. All right, we're going to go back to Ray. Ray, you're in the hot seat today. Lots of questions about NOSIs. If you're requisitioning a discharge of a PPSA interest, can you accept an undertaking, or must you have that discharge on closing? There's various versions of this question about discharges of PPSA.
Normally, an undertaking would be sufficient. However, the way the act is set up, if I understand it, and Rebecca may maybe confirm, only the lawyer for the existing owner can register the deletion. So after the sale, the vendor's lawyer who undertook to discharge it would no longer be, their clients would no longer be the registered owner and therefore could not register the deletion. Rebecca, am I correct on that? Sorry to put you on the spot.
Yeah, so the registered owner can delete, but also a chargee. So a chargee can also submit a application to delete a NOSI. We haven't actually had a situation where a previous owner has attempted to delete prior to or subsequent to the transfer. That actually hasn't been raised with us yet. I don't initially see an issue with it if we see that they are the previous owner, because they would have actual knowledge to allow them to make the statements. So it's not set out in the bulletin because it never arose. Right now, we're seeing people deleting prior to the registration of the transfer. because nothing more is required. So it's a pretty straightforward application. So they usually submit for registration prior to the closing of the transaction, not with an undertaking to do so following.
Well, there's the advantage of coming to these presentations. You get it directly from the Director of Titles.
Thank you both. Brendan, I have a question for you. I'm going to read the question directly. It's a little long. I'm going to try to shorten it while I read it. It's about restrictive covenants. If there are 3 nearly identical clauses shown 3 times in the contract, and 2 of the 3 have been deleted, and a third one hidden in the restrictive covenant, but registered on title, eventually the seller tries to buy back the property. Is this legal or is this some fraud? Do you have any thoughts on it?
Well, I think in terms of whether it's fraud or not, that's something that, right, you have to start looking at intent and sort of what's happening behind the scenes. So I don't think that's possible to answer. I'm not sure about sort of the legality of going in and deleting, deleting a couple and then leaving one sort of embedded in the document. If it's still on title, then then it may still be valid if it's not been deleted. I'm not sure if Rebecca has any further comment on that.
Sorry, I was just looking at the question and I'm not sure sort of the circumstances of what these restrictive covenants are, like what document types they're in and whether they are identical or whether they differ. Do they benefit different lands? Like it appears the same with the same covenantor and covenantor E, but they have different benefiting lands and therefore the release of some doesn't indicate that all should be released. So really without having more detail about the actual scenario and what these registrations look like, it's difficult for me to answer that question.
That's fair, thank you. And then a lot of the questions we do get are very specific and just, to attendees, it's hard to answer them without having more information. Rebecca, since you're on the speaker screen, this is back to the POAs. There's a lot of questions about POAs. We will get to all of them, but this one, if the donee's name is misspelled in the POA, what is the proper procedure to confirm the correct name of the donee, if not able to make a new POA?
So if a donee's name is misspelled, but it appears to be the same name, then we would accept a law statement that is one and the same person. However, the name was misspelled. If you have like John Smith and you have, something totally that is not John Smith and it is not appears to be a typographical error, then we may not accept a law statement, that Mary Brown really was intended to be John Smith. But if it's clear that it's a different spelling of the same name or a misspelling of the same name, then we would accept a law statement.
Perfect, thank you. And Rebecca, there are a lot of questions about will the LRO consider this and consider that? Is there a way for members of the bar to give suggestions or be involved in decisions? Do you have any suggestions on how people can voice their concerns?
So in terms of considering I saw some questions in there about what sort of evidence would be required for us to consider a change of capacity and that sort of thing. Is that what you're referring to? So
this question specifically is, will the LRO consider notifying lawyers who registered subsequent documents when a prior registered document has been returned?
Okay, when it's been returned, no. If it has been withdrawn, yes. So a return for correction, the document can still be corrected and it would maintain its priority. So there's no notification to subsequent registrants on a return for correction. However, if that document is not corrected or there's a fatal flaw in it and it will be withdrawn, then yes, the subsequent registrants are notified.
Okay, thank you. Ray, Actually, Ray, Brendan, Rebecca, anyone who wants to jump in. And I think I get these questions often too when I go for presentations, that if cybercrime coverage is limited, what else can be done by lawyers to protect themselves? So they implemented the steps suggested. Cybercrime still happens. What else is out there? It's a bit of a loaded question, but Ray looks like he's ready to answer.
Yeah, that is a very difficult question to answer because it's very fact specific as to what exactly the fraud scheme is. I think, as Brendan has mentioned, we have to be vigilant. I keep saying that fraud prevention is a team sport. You need to have everybody educated. That's the lawyers, the staff in the office, and the clients as to the potential scenarios. You know, keep looking at things. Everybody's busy. Everybody's in a hurry. We try to get things done quickly. And typically when you do that, that's when you get into trouble because you don't see, as Brendan's saying, sometimes a slight variation in the name of the email address. And sometimes they don't even have that. Sometimes it's as simple as the message is different. Brendan and I are communicating on a transaction. We're talking, we're exchanging emails. All of a sudden, I get an email that looks to come from Brendan, but all of a sudden, he's not calling me Ray. He's calling me Raymond. He's just got different a way of phrasing things. That's more difficult to be able to see, but that's a type of thing that unfortunately we're now into having to be aware of. And so it means taking a little bit more time in understanding exactly and looking at what you're getting to make sure that it's legitimate. If there's any suspicion whatsoever, any inkling you get, you should stop and then really consider on that. Because most of the time when lawyers call us that there have been a problem, they had a suspicion, they didn't act on it. And often they call us when they had a suspicion and they're right. So, very much, that gut feeling is very much there. It protects us. It's amazing how it kicks in. So definitely deal with that. Brendan, you have something?
I was just going to add with respect to mitigating loss once it's happened is given the LAWPRO sublimits, there is cyber insurance out there that's available. It's expensive, right? That's one drawback to it. And typically, they do want to see, I believe, fairly sophisticated IT systems in there. They come in, they test them, they make sure they're fine. Now, in one sense, that's a good way to to force yourself to ensure that you have the most up-to-date cybersecurity measures in place. And that's something that lawyers, of course, are always encouraged just to at least look into.
And if there's anything that happened that you think is wrong, act quickly. Everybody, people are embarrassed by the fact that they've been caught. They're embarrassed by thinking that they have to call LAWPRO or their insurer or somebody else. Don't wait. Time is very much at stake here, especially with funds direction. They go from bank account to bank account very quickly. And so if you act quickly, sometimes you can contact the bank that is holding the funds and get it frozen. But if you don't, and we're talking sometimes hours. So, as soon as you have something, you act on it. Call LAWPRO. LAWPRO, we have a helpline. Sophia, you're on it, and others there. But basically, call us, and if we can help, we will direct you to some resources or give you some have a discussion with you on the line.
Perfect. Thank you. Okay, so there's a few administrative questions. But before I get to those, there is a survey in the chat. Please complete the survey. It helps TLA and LAWPRO develop timely, helpful programming, so we know what you want to hear about and how do we do. This program is eligible for 30 minutes of professionalism and 1 hour substantive, and 1 LAWPRO risk management credit, which can be claimed at lawpro.ca for the 2026 policy. The replay of this program will be available on practicepro.ca. Click on CPD in today's event. It'll be available in the next 1 to 2 weeks. There's a lot of questions about getting questions and answers. The replay will have some of the questions that we have, will have all the questions that we pose live here and answers. The materials has the NOSI article and material that Brendan spoke on and some material that Rebecca spoke on. I want to thank the staff at Toronto Lawyers Association and LAWPRO working behind the scenes to make today's event smooth. Thank you to Title Plus for sponsoring this program. Thank you to those who promoted this event, and thanks to our speakers for sharing their time and expertise with us today. We would not have a program without our speakers. For LawPro, you can follow us on social media. Our LinkedIn page has substantive information, and our Instagram has short, fun clips. It's a great way when you're scrolling at the end of the night to see what we're talking about, and you could click, and it'll take you to some more substantive information. We're also on Twitter, X, I always say Twitter, X, and on Facebook. And that concludes our program. Take care and thanks, and we'll see you in 2025.